Good morning. Before we do get started, I'm going to just say I know we have some guests, and normally we don't take this moment, but there are members of the Rotary Club 100, I believe, who are here. And I wanted to acknowledge them personally. I asked my colleagues if it was okay. I'm a former Rotary Exchange student, so I do really appreciate the work that you folks do. And I'm glad to have you here. Welcome to your court. Hope you enjoy watching today's proceedings, and thank you for the work you do. You change lives, including mine. So thank you. With that, thank you folks for indulging me in that. So good morning. We are here for oral argument in case number 1, CV25-013. How about if I throw that one away? Some of you folks heard that argument, but you don't need to hear more of it. In 1 CACV 25-0219, Petersen et al. V. Fontes. These proceedings are being videotaped and audio recorded. They're also being live streamed. So we do ask that counsel please, when you approach the podium, state your name and your client at the beginning of each argument so that everyone knows who you're speaking for. Each side has 20 minutes. Appellate's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal. I know we also have a cross appeal. I don't know how counsel wanted to approach that, and if they were hoping to reserve a small moment of rebuttal just on the narrow issue of the AEVL. But I'll allow you to reserve that. But again, we do not, for either of you, watch the clock for you. So you will have to, you can tell us, we may mention it, but we're not going to save it for you. All right. Keep in mind we have read the briefs. We are on an accelerated appeal. We understand from looking at it that we must have our ruling out by Monday, which we will do. And so our plan is to have it out by the close of business on Monday, which is 3 business days. And so in that regard, we are very familiar. We've worked very hard to make sure we were ready for it today because that's not a lot of time between now and Monday. So counsel, if you're ready, you may proceed.
Thank you, Your Honor. Karen Hartman-Tejas on behalf of Appellant and Cross Appellee, Arizona Secretary of State, Adrian Fontes. May it please the Court. The Superior Court's judgment in this case should be reversed for 2 independent reasons. First, because the plaintiffs do not have standing to challenge the provisions of the Arizona Election Procedures Manual that are the subject of their complaint. And second, even if we get past that standing hurdle, none of the provisions that the Superior Court considered conflict with the operative statutory scheme. And accordingly, even if plaintiffs get past the standing problem, the Superior Court's declaratory judgment and injunctions should be vacated. As the Court has noted, there has been extensive briefing with which the Court is familiar, so I won't belabor the standing question, especially.
Well, counsel, why don't we just get to the point then?
All right.
Your main argument is this is a legislative delegation. The Montenegro case was a voter delegation, and our Supreme Court has made the comment in Montenegro that it doesn't matter. It's of no consequence. Separation of powers are separation of powers, and encroachment is encroachment. So tell me why this case doesn't fall within that standing when the legislature has said they disagree with your client's interpretation, they've gotten their legislators' permission to bring this, and they've alleged an institutional injury.
Certainly, Your Honor. I think that it's important to look at what the Montenegro court decided and what it didn't decide. It decided only the question of this delegation. And the delegation of authority to the Secretary in ARS 16452, the statute that provides for the Election Procedures Manual, is not challenged in this case. They challenged only the sort of statutory interpretation that led to certain specific provisions. They haven't said that the Secretary doesn't have the authority to issue these rules.
Well, haven't they said, though, that he didn't have the authority to encroach the way he did, that he had the authority to adopt a manual that conformed to Arizona law, period, and that if they believe he went too far, that he has encroached?
Well, I think it's important to really look at the difference between the 16452 and the statutes at issue in Montenegro, because that statute really changed the balance of power between the legislature and the, in that case, the Clean Elections Commission, which had the rulemaking authority. The Montenegro court said, quote, that it described the delegation as, quote, carte blanche authority without limitation by the legislature. There's an omission in there. And that established hegemony for agency rules over contrary statutes. That's not what we have here. The Supreme Court in several recent cases has established sort of the guidelines for determining whether an election procedures manual provision is not enforceable in that, in the McKenna, Leach, and Liebson cases that are cited in the papers. It's just really, we have a very different situation.
Perhaps we should move on to the substance.
Certainly.
So what I'm going to ask is, can we talk about mootness?
We can absolutely talk about mootness, Your Honor. Do we want to talk specifically about mootness with respect to the statewide canvass provision?
The statewide canvass provision.
Absolutely.
And I think one of the key question that I have is, your client has said, this is the provision that they're challenging, this is the provision that's in the proposed version. And I took it, although I don't know that it was perfectly clear, that your client is avowing that the current provision, the 2023 manual provision, will not appear in the 2025 manual because the legislators have responded saying, wait, it's not finalized. Secretary could swap that in again. Is your client avowing that what he's going to pursue, at least, is the provision that we see in your brief, and that he will not pursue the section that is in the 2023 manual?
Your Honor, I can make that avowal.
Okay.
As the plaintiffs pointed out in their supplemental brief, this is not solely within the hands of the Secretary, and the AG and Governor could ask for a change, but
would the Secretary agree to a change that puts the 2023 manual back in place? That's the question. Because if not, then it's not moot.
Right. I can't see that happening. Obviously, it's a negotiation. If it means that the EPM will not be issued timely as required by the statute, because the Governor and the AG won't approve, but that is not the factual situation in which we are existing today. So just maybe another point or two.
And Ms. Hartman-Tejas, just to be clear here, if we determine that issue is moot and we don't reach that issue, and your client does go and tries to put the 2023 provision back in place, would you concede that your opponents have standing to challenge that?
I mean, setting aside the fact that we don't believe they have standing at all, but if the legislature has standing to challenge individual provisions of the EPM, and there were some reversion to the 2023 version, yes, we would concede that. I would like to, since we're talking about this issue, I would like to make just a couple points.
Let's talk about it, if it's not moot, why your client's right.
Certainly. So on the statewide canvass provision, the Superior Court recognized that this issue is not ripe for determination. So separate and apart from legislative standing, there's no live controversy with respect to the statewide canvass provision, and the Ninth Circuit essentially reached that same conclusion. there's case law that basically says that, ripeness and standing are kind of hard to
We're not talking about the
untangle.
Ninth Circuit case that has the issue of the juror questionnaire. We're talking about the other Ninth Circuit case.
We're talking about American Encore versus
Thank you. I
Fontes.
just did, yes, we got two of them.
So you're correct. Yeah. So this is the one in which this specific provision of the EPM had been enjoined by the Federal District Court, and the Ninth Circuit overturned that because of lack of standing. So there's lack of standing and ripeness. The sort of thing that would necessarily come to pass in order for the secretary to canvass an election without the votes of a county was purely speculative. Hasn't happened. It, in fact, has never happened.
Almost happened, though, didn't it?
It got close, but it didn't happen because the secretary did what the secretary has avowed in American Encore, and here what the secretary would do is seek mandamus relief from the courts.
And as
And that is
proposed
what
in the 25 manual, pursue the legal remedies that he would have the authority
Yes.
to pursue without trying to say what they are.
Yes.
And that would be coming to the courts to do that.
Yes. And that is essentially required by the statutory scheme. There's no wiggle room in the deadline. And so, and there's a separate statute that imposes a criminal
Isn't the
penalty.
problem with the language, there's also no wiggle room in not counting all 15 counties?
And that's why the court of
Which is why the
intervention
problem is, yeah.
would be required. This provision in the EPM is designed to explain to the counties the very negative consequence of them not carrying out their own statutory duty. I just wanted to make a note about plaintiff's argument in their supplemental brief on this question about that vacating the trial court's decision wouldn't be appropriate because this is the change to the statute that moots.
Well, to the manual that moves it.
I'm sorry. Thank you, Your Honor. The change in the manual that would moot their challenge to the provision in 2023 is.
I think our options are we can affirm, reverse, and if it's moot, we don't touch it. And then it sits there for what it's worth.
All right. Well, I will, if the court.
If we could move on to the juror questionnaire.
Sure, I'd be happy to. All right. So the juror questionnaire provision implements the Secretary's state statutory duty to engage in voter registration list maintenance, including provisions regarding removal of ineligible voters that are consistent with the National Voter Registration Act and the Help America Vote Act. That shows up in ARS 16168J. And so throughout this litigation, the Secretary has acknowledged that the procedures in this juror questionnaire provision do differ from what is in 16165A9. But it is because of the Secretary's duty to implement the NVRA, that is both a federal and state duty, that difference exists.
So I was going to say, and it seemed to me it was clear in the briefing, but your client acknowledges that they are not consistent. The manual doesn't follow Arizona law directly in terms of what the section says should happen when a juror questionnaire comes back, which is cancel the voter.
Your Honor, I would tweak that just slightly in that it doesn't follow 16165A9.
Okay.
But it does.
No, I appreciate that. It doesn't follow that section of the code.
Yes. Yes.
I understand your argument, though.
And
that he also
in the
has to-
2025, I'm sorry.
Go ahead. That he also has to follow the NVRA.
Right. And, indeed, the NVRA preempts contrary state voter registration statutes. It's very clear. It's the U.S. Supreme Court laid that out very clearly in the Arizona Intertribal Council case. So
How is it there's a direct conflict? I know the Seventh Circuit has said there is. There's some other now meaningless authority that's out there that might suggest a different result, the one dissent, at least from the Ninth Circuit, that no longer stands. So why is it a direct conflict? Why should we follow the Seventh Circuit, which isn't controlling, on this court?
Well, two reasons. One, the operative decision in the Arizona Alliance for Retired Americans case, we like to call it ARA, to be quick,
That's fine.
is right now the district court injunction enjoining of another section of 16165A9, and that is an injunction in a case in which the secretary and all 15 county recorders are defendants, so they're sort of bound by that. So it makes perfect sense that the secretary looked to that and that case's decision to follow the Seventh Circuit theory when drafting the 2023 EPM.
Well, is the Seventh Circuit correct? Because it's not binding, and there's no binding authority. And the Ninth Circuit actually won't be binding authority on us, which is an interesting little twist. But
indeed.
Why is it right?
I think Your Honor noted in the dissent in the this court's ruling on the stay application that when a federal court of appeals rules on a question of statute, a federal statutory question, I mean, or a federal question, this is a sort of an equal protection question, that
it has persuasive
our courts have, yes, exactly. But in any event, the reason that the state statute conflicts with the NVRA is that the NVRA requires that when the reason for removal of a person from the voter registration rolls is a change in residence, that the information about that must come directly from the registrant, from the voter.
And why does not a response to a jury questionnaire comply with that requirement?
Because the information that the county recorder receives is not directly from the voter. I mean, the language in the ARA case is unequivocally from the voter. The statutory scheme, 16165A9 and 21314, provide that the recorder gets a summary created by the jury commissioner. This is very similar to a voter registration entity receiving information from the motor vehicle division, which is what happened in the Indiana statutes that were just decided by the Seventh Circuit. So it's because there could be mistakes, because the recorder doesn't receive the jury questionnaires themselves, and the statute provides that those are destroyed within a short period of time. That's the sort of the problem there.
Would it be different if it required the county recorder or the jury commissioner to forward the actual forms? I know they need to be destroyed, but let's say the statute just said, send the original forms to the county recorder.
It certainly could be different, especially if all of the forms said,
I understand.
if you say this, you're
Do we know how many counties forms don't at this point?
I'm sorry, Your Honor?
How many county forms don't at this point?
I'm afraid I don't know the precise number. It's in our briefing. It's
Okay.
about a third.
I
mean,
didn't
there's
know
sort
if
of
you
like
had
three
more.
different buckets that they fall into.
Okay.
If my time is relatively short, so perhaps if the court has questions about either of the other substantive provisions, I can hit those.
I would say, why does it matter? And counsel or my colleagues, okay if we give an extra 2 minutes so we make sure we cover everything?
Yeah, that's fine.
All right, we'll do that when we're done. Why does it matter that the 2022 cycle had begun? Because the voters could just vote, and then that would fix it. And so why does that matter?
Well, because a voter has a right to vote or not vote. There are some voters who only want to vote in municipal elections, and they don't want to vote in statewide elections. And several of the municipal elections had already passed by the time that the ABLE provision became effective in September of 2021. And really more importantly, the election procedures manual takes on this gap-filling function. The statute doesn't say the first time these able notices go out will be by January 15th of 2025. It says, it defines what an election cycle is, which is a full 2-year from January 1 of the odd-numbered year to December 31 of the even-numbered year. But it doesn't say, specifically that this goes into effect in 2025. And the plaintiff's argument essentially is that it says that when it does not. And of course, the plaintiffs were the masters of what the statute says.
How is the footnote in 58 not the Secretary declaring what is and what is not an error that we will accept, that it is strict compliance if it's that little error? How is, by saying the difference in a phone number, email, residential address, what controlling authority does he have to say that those things won't ever constitute it, especially when the election manual constitutes a statement of law?
Well, I think there's two different things. One, if you look at what the body of that section, the paragraph to which the footnote is appended says, the Secretary of State's office has no obligation to review the substance of circulator registrations to ensure that accurate or proper information has been provided. The circulator remains solely responsible for compliance with all legal provisions. The plaintiffs did not challenge that. And if you look at ARS 19-118, it directs, I think it's 118B5, circulators have to sign an affidavit that says this is accurate. So it doesn't fall to the Secretary to determine accuracy. If they get a registration,
which is the point. Why is the Secretary in footnote 58 saying these things won't be? It's not up to the Secretary.
It's not up to the Secretary. It is sort of it's the responsibility of the circulator or the proponent of the initiative, and on the back end of the courts, if there is a challenge.
So why is the Secretary even doing this?
Perhaps it wasn't the sort of clearest drafting. The intention of it was to explain some of the court decisions that already had gone before. I think it's Liebson that says if you leave off a unit number for a residential address, that's okay. It was intended to sort of address that. It probably could have been omitted.
Okay. All right, thank you. You're at your time, and we'll add some time here. We'll figure out exactly how much here once we get through councils, because council may be hoping we have more time.
Thank you.
Go ahead, council.
Good morning. May it please the court. My name is Tracy Olson, and with me is Joe Canefeld and Corey Langhofer on behalf of President Petersen and Speaker Montenegro. Mr. Langhofer and I are splitting the time, so I'll briefly address any standing questions the panel has, and Mr. Langhofer will address the merits. So I just want to start by responding to the Secretary's point about what Montenegro says and that it's maybe limited to delegation. But what Montenegro stands for is that the legislative power is inalienable. This means that you cannot give away the power and you cannot use the power. That's supported by the plain text of Article 3, and it's also supported by the cases that are cited throughout Montenegro, most importantly, the Roberts case.
So I just want to make sure I understand, because you're seeking standing to challenge. And one of the things that was sort of hinted at but hasn't been said is that the Secretary has no ability to try and harmonize the statute with the NVRA if there's a clear conflict. Your clients aren't saying, look, if there's a clear conflict, the Secretary has to adopt federal law or state law and let someone sue him because the manual doesn't follow the federal law. That's not your client's argument, is it? And I know that it tracks the question on standing, and you may not quite understand it yet. But your client isn't saying that if the Secretary looks at this and says, I think the statute violates federal law, The legislature has told me to make sure it complies with federal law under the NVRA. Your client recognizes that the secretary at least has a statutory authority to do that.
I appreciate that the secretary has a statutory authority to follow the NVRA, and I think what Your Honor is saying is what happens when the secretary feels as though he's between two competing obligations.
A rock and a hard place, we'll call it.
Right, and I think that there's, first of all, I think the standing depends on the facts and circumstances of the case, so I don't think...
But let's stay focused on that, though. So, right. But when he's between a rock and a hard place, and he says, I can follow the NVRA, or I can put in the provision, for example, the voter registration. I think I have to follow the NVRA, and so that's what he puts in. Then that's when you've got your injury, if you think he didn't do it right, or your client, right? And that's when you can come in and challenge it. But he has the ability to try and make that call.
Respectfully, no, Your Honor. I think that...
So the secretary would have to adopt. That's why I'm troubled by this. Plainly, SCOTUS has said this is unconstitutional. And the secretary is still going to have to implement a voter provision in the manual that says it's unconstitutional until he's sued? You're not saying that, are you?
What I'm saying is, unless and until the U.S. Supreme Court or an Arizona court says that the particular provision of Arizona law is unconstitutional, it's not within the scope of the secretary's power to harmonize. That's the court's job, and Leapson says that.
Right, and the way the court does that is he adopts what he does his best to do. And that means he's got to follow both. And keep in mind, your client told him to do both things. Make sure he follows the NVRA and Arizona statute. Mm-hmm. He does his best. And then what Montenegro says is if you disagree, your client disagrees, they have standing to come over here and ask the court to resolve the issue, right?
And that's kind of what happened.
Otherwise, you'd never need it, because they would only be able to repeat the words in the statute.
Well, the legislature has standing as soon as the secretary announces policy on issues that the legislature has already announced policy on. So the legislature announced its policy.
But you're saying he can't harmonize even under the statute when he's got this?
No, not in these circumstances. So I direct the court to Dobson. Dobson's a case where the officials there had what they perceived to be competing duties, and a state law that they perceived to compel them to do something they felt violated another duty, and they had standing to bring that suit. So perhaps it'd be a situation
But my point is, the executive always has to do their best. And they do their best to make sure that they follow the federal law when they're told to, which is what he's been told to do, and the state law. And when they can't, that's when you get, and you disagree that they've done it right, then your client is standing to come over here and challenge it, so do other people. But to suggest that they can never vary at all is what's troublesome to me, because I'm not sure what the executive is supposed to do then.
Well, the problem with the way that the secretary has done it, I think it'd be different if perhaps it was done outside the election procedures manual. But the election procedures manual is given the force of law. And in fact, it's given the force of criminal law. And what the election procedures manual regulates are these recorders, right? And so the election officials, the county election officials, are obligated to follow the election procedures manual. Now, there's no court case saying that...
Perhaps we should just move on from that point. So go back to the standing. Why is it that you believe they're standing?
Well, what we've alleged here in our complaint is that there's been a use of legislative power. We've identified areas where the statutes conflict with the election procedures manual, or should I say the election procedures manual conflict or exceed the statutory delegation. In Montenegro and the other legislative standing cases show that an exercise of legislative power is enough, and the allegations here are also enough.
And that the encroachment is what in the legislative era, legislators have authorized this, gives standing.
Correct.
Okay, thank you.
Thank you.
Seventh Circuit time.
Good morning, Your Honors. May it please the Court. It's a pleasure to be here today, particularly with Rotarians. My wife was a foreign exchange student through the Rotary Club 30 years ago in Venezuela. So
very cool.
Pleased to be here. Seventh Circuit.
Actually, state your name first and who you represent.
I'm sorry. Corey Langhofer. I'm here for the legislative plaintiff of cross appellants. If you like, we can talk about the Seventh Circuit.
Let's start with what is the problem with the juror questionnaire piece. Why is this either the Seventh Circuit wrong, or how has the Secretary misinterpreted the Seventh Circuit, and why shouldn't we look at it?
On the juror questionnaire issue, I think the best authority we have is the language of the NVRA itself.
The language of?
The NVRA itself, 20507, I think it's D1A, says you can't just remove someone from the voter rolls unless the voter confirms in writing that they've moved outside the jurisdiction. That's precisely what we have. Is exactly what's happened here. The voter receives something in the mail, with a couple of exceptions of counties we can talk about in a moment if you'd like. They're told, you got to show up for jury duty unless you moved away. And if you tell us you moved away, we're going to take you off the voter rolls.
So who do they confirm that in writing to? Can I send a note to my neighbor saying I've moved, and can my neighbor turn that in and get me off the roll?
The NVRA answers that question for us.
Oh.
They have to provide that information in writing to the state, according to the NVRA. And the state of Arizona, of course, includes the jury commissioner, and the jury commissioner is also authorized by statute to transmit this information to the county recorders and have them take them off the rolls. I want to sort of address this idea that any alienation between the person who receives the communication from the voter and the person removing them from the rolls is sort of like breaking the chain. That's just not true.
But the Seventh Circuit said it was.
The Seventh Circuit was dealing with cross-state, like interstate notices, not something within the same state. And the NVRA is worried about communications within the same state. The state has to receive this written confirmation from the voter.
Did there say anything in that case that suggests it could have come from something inside the state and the result would have been different? Because I didn't see it.
Well, yes. I think at the end of Sullivan, there's a quote there that we have in our, I think it's our response brief. And it says, this is a really helpful language for us. It says, look, if you're receiving a communication generated by the voter, then that would be sufficient. They seem to be. So I read that language to mean that they're concerned that someone says something to another state, the other state then says something to this state, and then this state then removes them from the roll. That sort of daisy chain doesn't work. If the state.
But we have a daisy chain here. You said something to a jury commissioner creates a list, doesn't send the original document, and then sends that on to the county recorder. How is that not also a daisy chain down the road?
Because the MVRA defines the receiving party as the state. And now, so the response may be, well, the jury commissioner is technically not the same as the person who removes them from the voter rolls, so maybe that communication within the state is material under the MVRA. I just respectfully submit that can't hold up under, if you
Has any other jurisdiction drawn that distinction? Seventh Circuit's the only one out there at this point.
Correct. I think the Seventh Circuit's the only one who's addressed it, apart from.
And we're waiting for the Ninth Circuit.
Right, which, as you've noted, is persuasive. So let's think about this. Section 165 says the recorder will remove the person from the voter rolls, but we know it's not actually the recorder, him or herself, right? They've got staffs. Even the smallest county, they have at least 3 or 4 staff members. And it's not true that it has to be the recorder, him or herself. And we also
But the recorder's office has to receive.
Correct, but I don't
Okay, it can't just go to, you can't mail it to the jury commissioner and then the recorder's going to act on it.
So if we're broadening the language of the statute, which says the recorder shall remove it, to the recorder's office, because that's, of course, the way that works in practice, we don't say, well, the guy in the mailroom who receives the form from the voter isn't the same one who does the removal. Like, we accept that level of alienation.
Within the office, within the complete jurisdiction of the elected county official. So now the jury commissioner serves at the will of the Superior Court judge, or presiding judge, completely different. So now you're taking it out of that.
So.
And they don't send the form. This isn't like the post office delivering it.
Correct.
So I want to make sure we don't get into that loop. What it is they then send a summary.
So let's ask ourselves, this distinction between jury commissioner and the person who does the removal, under what law does that matter? It's not Arizona statutory law. Arizona statutory law says the jury commissioner gets it, sends it to the recorder, you remove it. So Arizona law is fine with it.
Right, I don't disagree.
So now we're looking at the MVRA. Does it matter for that? No. The MVRA says the state.
So can I report that I've changed addresses to literally any public employee in the state of Arizona, and that's sufficient to remove me from the voter rolls? If I tell, a city employee, if I tell a police officer that I've moved, is that sufficient to, under the MVRA at least, to remove me from the voter rolls? Is that?
For federal law, that is consistent with the wording of 20507.
But it has to be in writing, just to clarify? Would that have to be written?
Also, federal law requires a written confirmation to the state. So federal law is satisfied here. State law, of course, says, well, it's got to be to the jury commissioner, and there's circumstances.
But they could have made it the dog catcher from your position. And the dog catcher could forward it on.
Obviously, there's good policy reasons we wouldn't want to do that.
No, but your reading of the statute is it could have been a dog catcher.
That's correct. My reading of the federal statute is also that you wouldn't even need to send the follow-up communication to the voter. You've got a written confirmation from the voter saying, I don't live there anymore. That would be enough. We have, as a matter of grace, said, look, send them a confirmation. Say, did you really mean this? Because if you did, we're going to take you off.
And there is some sense of this that residence is not always the same. There are a lot of people who don't live here for jury duty. They're in college in New York, but they're still here. They're still voting here. And you're suggesting that if they send in that note saying, right now I'm living in New York, they come off the voter roll. They're canceled. They're not just put on that inactive list, which is where federal law would put them.
So there is, colloquially, people could use residence in many different senses, but legally, residence is defined.
Okay.
Physical presence with intent to remain. So the reason, if I go to undergrad at NYU, but I maintain my permanent residence here, I've got a physical presence in New York, but I don't intend to remain just there till I finish my schooling, you maintain your legal residence in Arizona. If someone confuses that, understandable, they're not thinking about it.
I think it is understandable. That's the thing, because we don't tell them, by the way, in filling this out, we're just asking you, and the legalities of saying this is my address, I think are lost on almost all voters.
Well, if that's the case, if we will say a good faith misunderstanding of the law is an excuse, then I think we're going to introduce a lot of problems, and not just this case, but virtually every case.
Mr. Langhofer, could you address the sort of variable implementation, if you will, of 21-314, the notification to the jurors in the jury questionnaire that some jurors are being notified that, hey, if you say you don't live in the county, you're going to have your voter registration canceled, and in certain other counties, for instance, the county where I come from, that may not be the case.
So if, let's say, 2 counties sometimes don't provide the correct notification, the solution to that is to fix those 2 counties' notifications. It's not to invalidate a different statute in all 15 counties. So that's a bona fide problem. Let's correct that. If we know who they are, we'll probably sue them. But we don't know who they are at the moment. And the solution is not to invalidate a different statute in every county. It's just a mismatch of the remedy and the problem. If there was, the MVRA has a private right of action. If someone says, look, you removed me from the rolls. I don't think I was supposed to be removed. I didn't understand this communication would have this sort of effect. Let's say I was at NYU for schooling, and I thought I was sort of responding in the colloquial sense. I don't live there anymore, but legally, I didn't get it. Well, there's a private right of action under the MVRA. You can say your Arizona rights weren't followed. You can sue.
But it's not going to get them. They're not going to get through that process and be able to vote in an election that they realize they've now missed the opportunity to re-register, and they're being told they can't vote. They might figure it out on election day.
They received the
notice. So you say it's there, but how?
They receive the notice, and they can respond to the notice if they say, oh wow, I didn't realize saying I was away at school meant I couldn't vote here. Respond to the notice, clear it up. Again, under federal law, I don't think you're required to send a follow-up notice saying, did you really mean this? Because we're going to take you off the rolls. But we do that as a matter of grace because we want it to go smoothly.
But then under federal law, there's a reasonable, at least our reading, that says we can't just kick them off. You may disagree with it, but you can't say it's a completely unreasonable reading.
Well, no, I wouldn't say it's frivolous.
Yeah.
But I will.
I'll take that.
Yeah. But let's play that idea out and see how far that goes. So there is an idea that exists in academic circles that requiring voter registration is racist. This is an idea that serious academics talk about. They tweet about it a lot. It's got some following. As far as I can tell, it's never been adopted by a court. It's would be difficult to prove for reasons we don't have to get into here. What if one of these academics were elected to this Secretary of State position, and he or she said, I think voter registration is racist. under the 14th Amendment, which I must follow, of course, I took an oath to it, I will invalidate all the voter registration statutes in the state. Well,
Then you would sue, which is what we're doing here, and we would have this discussion.
correct, but you can repeal the
And that's the
statute.
standing issue.
If
Your
you want,
client would have standing to sue on,
well, I'll take that.
arguably.
Well, we're here.
Arguably, I didn't do it with argument.
I do want to talk about the AVOL issue briefly.
Yes.
And there's been the suggestion in the trial court and here again today that there's some ambiguity about what AVOL requires. I don't see it. So if we can time travel back to January 14th of this year, read the statute as adopted and it says, okay, on January 15th of odd-numbered years, okay, tomorrow, we know no ambiguity about the date. We know what that date is. The county recorder has to send out some notices, okay? To whom? Well, it defines it. It's people who haven't sent in their ballots in 2 election cycles. You know exactly who they are. We've got extensive records on this. It's just objectively correct. What's ambiguous about that? The statute doesn't say 2 full election cycles beginning after the effective date. It just says January 15th, odd numbered years, you send it out.
It also doesn't say, which probably would have been helpful for your client in hindsight, that starting in January 15th of 2025 in every odd-numbered year. And so it's not quite that clear.
The
Because that's how they can say that. In fact, they've said that in other statutes enacted during the same legislative session. And if they wanted to apply that way, they know very well how to say, starting with the 2022 election cycle.
I think that requiring the legislature to have language that is redundant of the effective date language in the state constitution would just be a mandate for surplusage.
No,
The
I
Constitution-
think, let me ask you this. The effective date was September 26th, I believe, of 2022.
Correct.
That was after the 2022 election cycle had begun by statute.
Correct.
Legislature presumably understands that. That's what we do. We presume they understand their own laws.
Sure.
I worked there. I
Yeah.
certainly felt I was presumed to know that. So they knew when they enacted it that that legislative cycle was already in place, and they also knew the effective date would be after that election cycle started. If they wanted to be clear, why wouldn't they have done that? That's not necessarily redundant to do that. And they've said it. The thing is, they have said it in other places. So if you're saying they're redundant, they're at least willing to be redundant.
It's not the way we see it. On January 14th, 2025, there was no question that following the language of the statute as written, the next day something should happen. That if you look at the statute, there's no indication that it would not apply until later or started applying.
There's no indication that it was retroactive or that it would apply. I mean, we have to read it as saying, starting with the 2022 election to be abundantly clear. Otherwise, there's at least an ambiguity in there.
Well, we would apply the default rules of retroactivity. So if we're going to get to ambiguity, we have to sort of define what's ambiguous. So if we're applying the default rules of retroactivity, we're looking for a vested substantive right that's being abridged. Ask yourself, what's a vested substantive right? Certainly the right to vote is a substantive right. Arguably, the right to vote by mail is substantive. I think that's really debatable, but let's just go with that because the conclusion's the same either way. All right, if the right to vote by mail is substantive, is it abridged by something that happened exclusively before the effective date? Definitely not. Definitely not. After the effective date of this law, you still had to fail to vote. And then you still would have to fail to respond to the notice that comes in the mail. Like, these things happen, even though some of the relevant events happen before the effective date, other things done by the voter must happen after the effective date. Under this court's doctrine of retroactivity, there's no problem there. So you don't need to redefine it in statute because following the normal rules of retroactivity, it's fine. I want to say one last thing, if I might, that may reduce your workload. Listening to the argument today on the circular registration footnote, I don't hear the secretary defending the substance of the footnote. They're not saying this will have the fact of increasing the validity rate, changing the validity, or that should apply to anyone outside the Secretary's office. If they're not defending the substance of the note, if they're sort of redefining it or saying it really wouldn't have this effect, I don't think they've presented an appellate argument. I don't think there's any reason to sort of reach the substance because they're not saying the note does what it says it does.
Okay.
Happy to answer any questions.
What I'm going to do is I'm going to give, because you went longer than she did going over, I'm going to give you 2 minutes. I'll give you 1 minute for any additional rebuttal as to only the AEVL.
Thank you.
So we'll have to take, all right, well, they are fast. Good job.
Thank you. Just very quick points. First, on standing, Ms. Olson said that what Montenegro means is that the legislative power is inalienable. And I think the problem with that is that it, taken to its logical end, means there can be no delegation of authority to make rules. And I don't think that's what the Supreme Court meant in Montenegro, and I don't think that that's a correct statement of the law. I'd like to make another point about the juror questionnaire provision. And this is something it's in our briefing, but I didn't mention it before, and that is that the process set forth in the EPM that follows the NVRA process that would move those voters to inactive instead of immediately canceling their registrations, as the Secretary believes the NVRA requires. It has essentially the same effect because this is about residents, and in order to get off of the inactive list and get a ballot, you have to affirm your residence within the county. So the practical effect.
You have to either show up at the polling place or go to the county recorder's office.
Correct. So those.
And it's an in-person thing, right?
You can contact the county recorder, and
Okay.
they have lots of tools now to where you can affirm your address. And I just one further point also about the circulator registration provision, and is there's nothing in the statutes that gives the Secretary authority to sort of investigate the accuracy of each circulator's registration. And with that, I will ask that the court reverse the Superior Court's decision with respect to the 4 provisions challenged by the Secretary. Thank you.
Thank you. Counsel, you get a minute. I've never seen you waste it.
I'm sorry?
I've never seen you waste it.
I've been ruminating on this idea that in passing the ABLE provision, the legislature should have restated the effective date or when the timelines began. I guess the most concise thing I can say about that is the absence of redundancy.
Can you speak a little louder? I'm sorry, you're getting softer. I think
The absence of redundancy is not ambiguity. So if the state constitution says it will be effective in 90 days, they needn't say it again. It's not ambiguous if you don't repeat yourself. I'd be happy to answer any questions.
But is that the same as saying that it's going to apply to the 2022? I mean, I'm just not sure.
I genuinely.
I mean, the part of it is it retroactive? And that's what I think the Secretary has argued. It's not retroactive. It's just it doesn't apply until it takes effect, and that means it takes effect on the next one. That's the difference. And if you want it to apply, that makes it retroactive.
There is nothing in the text that calls into question whether the 2022 cycle would be used in the calculation. It's just the ambiguity is atextual, I would say.
Okay.
Thank you.
Thank you. All right, folks, as you know, again, we will be issuing our ruling very quickly here. We do appreciate you folks being ready and the argument. It's been enjoyable. Thank you to our guests. We'll take the matter under advisement.